Good afternoon, ladies and gentlemen. My name is Latoya Jansen. I'm a practicing attorney at De Wet Oosthuizen Incorporated, and we work in association with Marius Botha Consultants. I will be the presenter in today's training session, which will be focused on the collection of arrears school fees. Firstly, we need to look at which acts we need to consult to find the answers with regards to the collection of school fees. Firstly, we need to look at the South African Schools Act, and secondly, the Magistrates Court Act. I would just like to pause here just to explain that today's presentation is predominantly based on the collection of school fees in public schools. However, I will advise those of you who are currently employed and from private schools how the procedure differs as I go along. I believe that after the COVID pandemic, it has become more of a priority for schools to collect arrears school fees. Generally, schools have needed to supplement the budget from the department with school fees, but I think given the financial difficulties most of the country has experienced because of COVID-19, it has become quite a priority for schools to actually collect the arrears school fees. The purpose of this session is to briefly explain the legal process to you, as well as to let you know what is required from the school side before the legal process can begin. The big question is always whether schools are allowed to institute legal proceedings for the collection of arrears school fees. And this question is more of a question when it comes to public schools because they are governed by the South African Schools Act. And the answer is yes for both private schools and for public schools. However, the following procedure is more applicable to public schools, and once again, I will advise you how the procedure differs for private schools. Section 40 and Section 41 of the South African Schools Act makes it clear that a parent or parents are liable to pay school fees. And if they don't pay school fees, then the school is within its rights to sue the parent for the school fees they did not pay. It's slightly different with private schools because they are also allowed to collect arrears school fees, but this is not done in terms of statute. When it comes to private schools, then the parents actually enter into a contract with the private school, and the contract is the basis on which they are allowed to collect arrears school fees. But public schools are a statutory debt, so we need to find in legislation what allows a school to recover arrears school fees, and this can be found in Section 40 and Section 41 of the South African Schools Act. Now let's look at who is liable to pay school fees. The answer to this question can be found in Section 40, read together with Section 1 of the South African Schools Act. Section 14 says that a parent is liable to pay school fees, but what exactly is meant by a parent? Section 1 provides a clear definition of who is considered a parent in terms of the Act. And it is defined as 1, the biological and adoptive parent or legal guardian, 2, the person legally entitled to custody of a learner, or 3, the person who undertakes to fulfill the obligations of the above-mentioned persons. Point number 3 refers to situations where, for example, it is actually an aunt, an uncle, or even a sibling who enrolls the child into the school. So they do not technically fall into the first two categories, but they complete the enrollment form and they sign it. Therefore, they take on the obligations that a parent normally would have undertaken. With point number 3, this is also applicable to private schools because, like I indicated, it is based on contract. So it is the person who undertakes to fulfill the obligation in terms of the contract. So whoever it is that signs the contract with the school. You must, however, remember, and this is specifically with public schools, that if a person falls into the above-mentioned categories of a parent, They will not be liable for payment of school fees if they have received an exemption. If they've received a partial exemption, they will only be liable for a certain part of the school fees. And of course, the procedure for exemptions and partial exemptions can be found in the regulations relating to exemptions. And this is predominantly a function of the school governing body. When deciding whether or not to hand over a parent, you need to ask yourself the following questions. 1. Does the parent qualify for exemption? 2. If the parent has received partial exemption, have you made the necessary deductions? And 3. Has the parent applied for exemption? You may be asking, why are these questions of any relevance? Well, it is clear from the Act that the legislature, so the persons who have actually drafted the South African Schools Act, intended for schools to look at the financial means of parents before deciding to sue them. Now, nothing prevents you from proceeding to sue them. However, you may not be as satisfied with the outcome of legal proceedings, because if it is found that they do not have the financial means to pay, then there really is no way of enforcing the payment of the school fees, even if you have obtained a judgment against that defaulting parent. Arguably, the most important aspect a school needs to consider before handing a parent over is whether you have served a Section 41.5 notice on the parent. Here I'm referring to Section 41.5 of the South African Schools Act, which specifically provides that a parent must receive a notice indicating the following. 1. The parent is in arrears with school fees. Here you will also indicate in which amount the parent is in arrears. 2. The parent has failed to apply for exemption. And 3. Should they remain in default for a period of 3 months after they have received the notice, that the school will proceed with legal action. With regards to private schools, this notice is not applicable to private schools. However, a private school will still provide a parent with a letter of demand. However, I do not believe that the 3-month period will be applicable. Your contract will then stipulate how many days or months it may be that the parent has to remedy the breach of the contract. So the 3-month proviso and the fact that they have failed to apply for exemption, this is only applicable to public schools. However, private schools will also need to send a letter of demand advising the parent that they are in arrears, advise them by which amount they are in arrears, and advise them of the time they have in which to remedy the breach. The time will normally be found in the contract itself. If it is not specifically indicated in the contract, then I have found that the court will deem a reasonable period to be around a month's period, a month's time, in order for the parent to rectify the breach. Once the notice has been sent and the 3-month period has lapsed, then a summons may be issued against the defaulting party. Now that is where I want to just pause and just take a second to go back. As I previously indicated, that you cannot proceed with legal proceedings until 3 months has lapsed from the time that this notice was served. Now we need to look at what will be defined as instituting legal proceedings. Legal proceedings will deem to have been instituted if a summons has been issued against the party. So technically, nothing will prevent or nothing prohibits the school from handing it over to a debt collection agency who's not going to issue a summons before this 3-month period has lapsed, or even to hand it over to an attorney before the 3-month period has lapsed. But it must be borne in mind that it may delay the process of your attorney actually instituting the summons, because your attorney has to wait for the full 3 months to lapse before they can issue summons. What is also very important to note is that the Act specifically makes provision for 2 forms of service. These 2 forms are by registered post or by personal service. Why is section 41.5 so important? Well, section 41.5 creates a statutory requirement. What this means is that if you intend to make use of section 41 of the Act, and that is that you intend to institute legal proceedings for the recovery of arrear school fees, then you will be required to comply with section 41.5. This will become very important during the legal process, which I will briefly explain to you in the next slides. So once you have handed over the parent to your attorneys, they will more or less follow the following procedure. Two things that need to be noted is that it is not the only procedure that your attorney can follow. There are some deviations from this procedure to be followed, but I believe that this is the most common procedure followed. And secondly, I'm only going to be addressing you on the procedure to be followed if the parent does not defend the summons. If the parent does defend the summons, then it is a much longer procedure, and your attorney will advise you of that procedure as the matter goes along. The first thing that your attorney will do is that they will issue a summons. Roughly, this means that they will get a case number from court, because they will draft the summons, they will take it to court, the clerk will stamp it and provide them with a case number. The summons will then be taken to a sheriff who will serve the summons on the defaulting parent. It is important to note that a summons is a court document. Therefore, in terms of the applicable rules and sections in the Magistrates Court Act, your attorney cannot personally serve the summons. It has to be served via sheriff. Once the parent has been served, they have 10 days to defend the matter. Kindly take note that the 10 days is calculated excluding Saturdays, Sundays, and public holidays. So it is your normal Monday to Friday. If the parent doesn't defend the matter within that 10-day period, your attorney will request a default judgment from the magistrate. Default judgments are regulated by Rule 12 of the Magistrates Court Act. I will not be discussing the whole Rule 12 with you, but I want to specifically discuss Rule 12.6 Big A with you. This rule provides that if you are relying on an act as the basis of your claim, you need to provide the court with an affidavit confirming that you have complied with all the requirements of that act. Now note section 12.6a in relation to the section 41.5 notice is then not applicable to your private schools. So in the public schools case, the affidavit will, amongst others, have to confirm that they have sent the section 41.5 notice. But it is not sufficient merely to indicate that you have sent it. You also have to provide proof that you have sent it. What kind of proof can you provide the court with? Well, if there was personal service of the notice, then you will provide the court with a copy whereon the parent has actually signed that they have received the notice. And if you have opted to make use of the alternative means of service, being registered post, then you will provide the court with a registered slip from the post office. Once your attorney has obtained the default judgment, they will then proceed by sending the parent, who is now known as a judgment debtor, a notice in terms of section 65A, big A, 2 of the Magistrates Court Act. Now, this notice is in preparation for a section 65A1 procedure to be followed. but it is required that this notice is sent out before you can proceed with that. And roughly what this notice contains is it advises the judgment debtor that judgment has been granted against them. It advises them of the case number under which the judgment has been granted. It advises them of the day on which the judgment has been granted. It also advises them of the amount in which judgment has been granted. Now, the amount at this stage is not just the handover amount, but it also includes the party and party costs. Your party and party costs are your legal fees. It's your legal costs. However, you should note that party costs are specifically only the costs which are allowed for in the magistrate's court tariffs. So if you have an agreement with your attorney that your fees will be beyond what is provided for in the tariff, then you will still be liable for the fees that fall outside of that tariff. However, the judgment debtor, your defaulting parent, will be liable for all the legal costs that fall within that tariff. If the parent still doesn't pay after they have received the Section 65A2 notice, then your attorney will now proceed to send the judgment letter a notice to appear in court. And this notice to appear in court is done in terms of Section 65 Big A1 of the Magistrates Court Act. During this process, the judgment debtor will appear in front of a magistrate who will do a financial inquiry. What is meant by a financial inquiry is that the magistrate will determine how much the judgment debtor can afford to pay in monthly installments towards settling the judgment debt. It doesn't just involve, it's quite an in-depth process in the sense that the judgment debtor will be required to complete what is known as an income and expenditure form. So they will have to reflect what the income is and what the expenditure is per month. It's important to note that both parents, for example, if you are in a situation where the parent has remarried, but they have remarried in community of property, they will be expected to reflect the income, their income, as well as their spouse's income, because the court has to get a proper understanding of how much money this parent actually has available every month. In terms of the expenditure, they will have to provide bank statements reflecting the expenses per month. So they cannot merely state that this is how much they pay per month. They have to provide the court with a bank statement that confirms that that is actually what they spend on something per month. Another thing that is important to note with regards to the expenses in terms of the financial inquiry is that there is some sort of a closed list of expenses that the court is willing to take into consideration. And this closed list is merely necessary expenses. For example, your rental, your mortgage bond that needs to be paid per month, your vehicle, your transportation. It's basically all of your expenses that are necessary for every month for you to survive and for you to live every single month. The court will not take into consideration what is known as luxury expenses. These will include, for example, your DSTV payments, or if every month you go to the hairdresser to do your hair, even though it may be something that you pay every single month, the court will not take it into consideration because it is a luxury. It is not a necessary expense. Now, once the court has looked at that, they will determine how much you have, or how much the judgment debtor has available after paying all of their expenses at the end of the month, in order to make a just consideration as to how much they need to pay the school per month in order for them to satisfy the judgment debt. It should also be known that Once the magistrate has actually determined how much the person can afford per month, then that is made an order of court. So now we have something solid indicating that that is how much they need to pay every month. Now, what documents need to be provided to your attorney? Yeah, I just want to say that I myself used to work at a law firm where we did collections for school fees. And I've included this in the training because a lot of times you find that the problems with the matters are more of a practical nature. We may not have received everything that we need to receive from the school in order to ensure that we can properly draft the summons, that it can be served properly, and that we can actually obtain judgment against the party. You know, that we have complied with all of the requirements in terms of the Magistrates Court Act. So what is of importance, and this is both to private schools and to public schools, is the learner's application form or the enrollment form. For private schools, this forms the basis of your claim because your claim is based on contract. However, in public schools, the application serves as proof that the child is actually in attendance at the school and that the school did request the child to attend the school. So that is the purpose of the application form. The second thing that needs to be provided to your attorney is the parent or parent's personal details. Remember that it is very important that your attorney has all of the details because firstly, they need to draft a summons. They need to make sure that they have put in all the information in the summons that is necessary in order for them to succeed with their claim. So the first thing that they have to do is they need to correctly identify the party that they are suing. So you need to provide your attorney with the full names of the parent. And further an amplification of that, you need to provide them with an identity number. The court has to be satisfied that you have the correct parent has been identified. It is not because it can occur that two parents may have the same name and surname. So you have to satisfy the court that the person that is before the court, in the sense that you are suing them, is the correct person who is supposed to be sued. You also need to provide your attorney with the correct physical address of the parents. The physical address becomes important when it comes to service of the documents. If your attorney cannot properly serve the summons, they cannot proceed to obtain judgment against the parent. So it's very important that you regularly check in with the parents and make sure that you still have their existing physical addresses. Because I've experienced that parents don't always disclose a new address to the school. So if it is in any way possible for the school to endeavor to make sure that the details are regularly updated, that will also assist the legal process greatly. Now, these personal details are normally found in the application form, but if they're not in the application form, then please make sure that you obtain these details before you actually hand it over to your attorney. And that proviso is also applicable to private schools because once again, it is for the purpose of your attorney being able to put a proper case before the court. The third thing that needs to be provided to your attorney, this is for both public and private schools, is you need to provide a statement of account. Yeah, I cannot stress enough how important it is to provide a full and proper statement of account. The purpose of the statement of account is in order to show the magistrate how the amount that has been handed over has been calculated. You need to prove your claim. I have experienced in the past that sometimes if a school hands over a parent for more than 1 year, for example, that maybe in 2019 they were short with 2,000 Rand in terms of their school fees, and then also for 2020 they're in arrears. They will provide you with a statement which reflects a balance brought forward, and it just provides the amount. you need to provide them with a statement which reflects how that balance brought forward has also been calculated. For me, the general rule of thumb is you need to provide your attorneys with a statement that has an opening balance of 0, because then they will be able to exactly show the magistrate for which months you are actually claiming. When did they pay, when didn't they pay, and how did you actually calculate the amount that you handed over to your attorneys. Fourthly, you need to provide a copy of the notice in terms of section 41.5. So you need to actually provide your attorneys with a copy of the notice that you sent to the parents. For private schools, you will have to provide your attorneys with a letter of demand. Now, you may opt to not serve the letter of demand yourself, and your attorneys may also serve this notice on your behalf. With regards to private schools, the letter of demand becomes of importance at the calculating of costs stage, because they will request interest from the date on which the defaulting parent became in what is known as mora, or in default. So when it comes to a contractual relationship, you formally place a party in mora or in default once you have sent them a letter of demand. And the interest in terms of the court, the interest that the court will award will be determined from that day. If you don't send the letter of demand, then you will only be entitled to interest from the date of issuing summons. And some magistrates may also not grant it or not grant the default judgment if you have not served the letter of demand. And then the last thing that you need to provide your attorneys with is proof of service of the above mentioned notice. Now, this is important for both the private and public schools. Your public schools will provide proof of service of the section 41.5 notice, and then your private schools will provide your attorney with proof of service of the letter of demand. These two documents will hold no weight unless you can prove that the documents were actually served on the parties. Thank you so much. Are there any questions? I see that there are no questions today. If you at a later stage realize that there's a question that you would have liked to ask, or if there's something that I was not clear on, please feel free to direct any questions to the email address that you currently see before you. That is latoya@deaveoinc.co.za, or you can send it to admin@deaveoinc.co.za. And if there are no questions today, I'd like to thank you for participating in our training today and hope you have a lovely day further. Goodbye.